Today I'm with Lisa Jemmeson from Jemmeson Fisher, Solicitors and Accountants. Good afternoon, Lisa.
Hello.
We're going to talk about the proposed changes to the Residential Tenancies Act.
Yeah, today's just a bit of an overview for property managers and for licensing in charge, just to be aware of what's being floated out there. This is certainly not in law, but it's just a bit of an overview about what's being discussed out there in the marketplace.
But is it going to come?
Eventually will come and we will see some changes, so I think it's just interesting to be mindful of what's coming. There might be some measures that property managers wish to take now under the current legislation that they may lose in the proposed changes. So
what are they?
Some interesting points come out of the discussion paper. So the Act's been out for 5 years, so this is going through a review process, and that's to ensure that the Act is still meeting the objectives that it was set out for, and that's to balance the rights of tenants and landlords under the legislation. So in the initial discussion paper that was released by Fair Trading, it showed that 1/3 of the 2.47 million private households in New South Wales live in rented properties, so it's quite a big market of rental properties. In the last 10 years, there's been a 7.2% increase in the number of tenancies lasting longer than 3 years, and we see a big push to try and encourage landlords to enter into long-term leases with tenants.
So over 7% going over 3 years now, increased into that.
Yeah, increased
that is
into
interesting.
it. So in the last financial year, 64% of all bonds were refunded, had been held for more than 12 months. So that's another interesting fact. As of June 2015, there were a total of 754,000 bonds held. They were holding a value of $1.2 billion, so a lot of money there.
Money in the bonds.
Yeah, in the kitty. So yeah, it's quite interesting. So we might start just by going through some of the things that are being proposed. And the first thing is pre-contractually about disclosures that are being made to tenants. And so this can include any proposal to sell the property, any court proceedings. So if there are proceedings before the Supreme Court by a mortgagee to take possession, then there are requirements to disclose if the property's flooded or if there's been a fire there in the last 5 years, if it's if it's on the loose fill asbestos register, any significant health or safety risks that aren't apparent on an ordinary inspection, and whether or not the property has been the scene of a violent crime in the last 5 years. And so tenants groups are really pushing to make sure that everything is disclosed up front so that the people contracting understand all the things that go with the property right from the beginning.
And if I was the agent, how would you recommend they disclose this?
Well, I think it's very important to go back and get updated instructions from your clients, especially if you're a new agent taking over the property, because you may not be aware of things that are required to be disclosed. So you're going to have that conversation with landlords and then document that as well. Now, what is interesting, and there's a big push from tenants groups to say that under the legislation currently, if there's a failure to disclose, then it's an offence. But they want some stick, so to speak. So what they would like is that it would still be a breach of the legislation for failing to disclose, but the remedy is to allow a tenant to be able to terminate for non-disclosure. And that's rather problematic, and I think that's where you're going to get a landlord's attention if they know that they're going to lose a tenant based on non-disclosure.
Okay.
Now, the other thing in relation to disclosure has been in respect to drug manufacturing and drug crime. So what they're looking at doing is making it necessary and a requirement for an agent to disclose if there's been manufacturing on the premises in the last 2 years, and also a drug crime. The problem is drug crime is very broad.
So we get asked about that. How does the agent know that there's been a crime there?
Well, we're going to have to ask questions. We're going to have to ask the landlord now.
How's the landlord going to know if there's been a crime there? If the agent gets prosecuted and comes out on a bond, and so he's never been to jail, then how do you know there's been a crime there?
We can only disclose what you know, but you have to make reasonable inquiries. And I'd suggest that a lot of agents locally would know
Right.
if there
Maybe.
has been an issue with a particular property.
So let's say that they've been charged, but it hasn't gone to court yet.
Well, again, this would come down to the definition of this term, drug crime, in the Act, and it will need to be defined.
Right.
Otherwise, it's going to be left to NCAT to develop the common law to describe at what point has the crime been proven and what point disclosure is required.
So it's going to be in the legislation, you think?
I think we'll see it in there, and I think it's necessary to see it in there. So especially where there's been manufacturing, so with these ice labs and whatnot, not every council has been as proactive to ensure that proper decontamination of premises are taking place. And so it's an issue that's sort of simmering out there in the community, because there are now claims being made by tenants that have rented properties that properties haven't been cleaned properly, and they have a personal injury claim because they're now ill, or their children are ill, based on the chemicals that are leaching out of walls and whatnot. So it is a live issue.
It is, very much so.
Some other things that are being pushed in the changes are in regard to rent increases, and so tenancy groups would like to see the frequency of rent increases limited, and also having them tied to CPI as well. Yeah, so that's an interesting one.
That is interesting.
Bonds is another big issue, and I think we were expecting different groups to make further submissions, and it doesn't look like we've had a lot on it. But for example, the issue of pet bonds has been raised, and with such high rates of pet ownership in Australia, a lot of tenants find it very difficult to rent with a pet, and a lot of tenants will offer to pay an additional bond if they can have the pet at the property, but of course agents can't take it under the legislation.
Just recently the insurers are going to insure for pets now.
That's right, Terry Shear and the like are now going to insure. That's right, which helps, but it would also help if there was an additional bond that could be paid. A proposal has been put so that no longer would the bond amount be capped at 4 weeks, for example, for properties over $450 per week. And there are certain circumstances which there is a view that it's warranted to charge an additional bond, and it might be where tenants don't have rental history, they're higher risk tenants, so they don't have the ability to show that they can pay, or situations where they have a pet, but it looks as though the 4 weeks is going to be capped, and that's also to include furnished premises as well. So the discussion paper looked at rental arrears as well, and there was a suggestion put out there about charging late fees, which the industry got very excited about, but it sort of died down, and that's based on the US model where tenants are charged late fees to encourage prompt payment.
What was the tenants' union's idea about late fees?
No, they weren't so keen. No. Inspections and privacy, so looking again to encourage long-term tenants. If you are a long-term tenant, trying to limit the amount of inspections that agents can do, so they're not coming through every quarter, some do, and then setting a definition for what is a long-term tenant, and also looking at privacy. And so some of the issues that are raised, that agents are coming through and photographing on periodical inspections all the tenants' goods. And so there's a discussion going on about how appropriate that is, what's the agent doing with that information, and can it be used. In Queensland and Tasmania, their acts prohibit the use of those photos, but not the taking of the photos. So we're trying to find some even ground there. You
can take the photos, but you can't use them.
Yes, that's right. So you couldn't use it in marketing. So when the tenants gave notice, for example, you can't pop it up on the internet and show all their personal possessions and whatnot. So in New South Wales, the Property Stock and Business Agents Regulation requires agents don't use or disclose any confidential information obtained while acting on behalf of a client or dealing with a customer. So you have that already in the agents legislation. Another thing they raised was rental housing standards, having minimum standards. And while in theory that's great, so for example in Tasmania they've recently passed legislation requiring rental properties to have certain facilities, heating, ventilation, cooking, running water, that was standard, but That aside, the problem where you start having these minimum standards and we have compliance issues, then the rents go up. And so we're trying to find that balance. Another thing in relation to termination notices, the agents that have been in the industry for some time will remember that with the amendments to the previous legislation, one of the windfalls for the landlord was pushing out a no grounds notice from 60 days to 90 days. But when it went to the tribunal, the discretion went and the tribunal had to terminate the tenancy. Well, there's lots of discussion around this, and has been put that these 90-day no grounds notices are used by agents as a retaliatory measure to get rid of tenants that complain or that we just don't like and would like to see it go altogether. So in the discussion paper there's talk of removing a 90-day notice, and what's being proposed is that there are more grounds for termination. So for example, if you're the landlord and you need to move back into the property because you're unwell or you've lost your job, you list it. So they're actually saying, no, you have to nominate why you're going to terminate the tenancy.
Wow.
It flies in the face of, your interest in that land. What you're giving to a tenant is a leasehold disposition, and it really does infringe on those rights. So it's being fought fairly strongly by the industry to say this is one of the wins that we got. Back in 2010, we'd like to keep it. So it'll be interesting there. Down in Victoria, their no grounds notice period is 120 days. They're looking at a German model as well, which is tied into the length of the tenancy. So for anything over 8 years, it's anywhere between 3 and 9 months notice, which we don't want to see.
That's something to watch, isn't it?
Yes, indeed. So if you've got any tenants that you think might be better moved on, you might be giving consideration to that now. Technology was obviously looked at because, we're changing the way in which we communicate with parties and how documents are signed. And there is a proposal in respect to SMS and email, and looking at removing fax as a method of service of notices, and looking at emails where email addresses are nominated on the face of the residential tenancy agreement. So if you nominate an address and you don't check it, we can still get valid service of notices.
Tenant has to opt in for that, but don't they?
Yeah, that's right. I mean, that's what's being proposed.
I think most property managers would hear a cheer when you say that.
Indeed. Yeah. Because a lot of, with the changes with the Australia Post now, with the delivery of notices, even though you've got deemed service using ordinary mail, most agents are hand delivering to the letterbox now for effective service. So those types of changes are good. And again, in New South Wales, Strata Scheme Management Act allows service of notices via email. So I think it's just catching up, bringing tenancy legislation in line. Now, some big changes in regard to domestic violence. So in the 2010 Act, provisions were put in respect to victims of domestic violence being able to terminate the tenancy by giving 14 days notice. And there have been a lot of submissions, not just from tenancy groups, but from women's advocacy groups, about how ineffective this actually is. And what the legislation currently requires is that victims need final orders, apprehended violence orders to terminate the tenancy. And the problem is in practice is that sometimes these can take 12 months. So it just doesn't play out well. A lot of victims
so they
don't
might be
feel
living there for 12 months and not feeling safe at this stage. Yeah,
that's right. So the proposal put forward is that the tenancy can be terminated immediately if there are interim orders issued. And that's problematic for landlords and for agents because in the context of AVOs, a lot of alleged perpetrators will enter into interim orders because interim orders are, look, just stay away from each other and don't go near the property.
And I agree to do so.
I agree to do so, and then I'll go have the fight about final orders. So it's problematic if people can terminate. So that's one area that they are looking at changing, but there is strong advocacy from property groups to say it's not fair on a landlord if people can go and get interim orders and then just walk out of the lease.
It could be a way to break the lease.
That's right. Now the other area is that tenants have always been vicariously responsible for lawful invitees onto the premises.
You invite someone onto your premises.
That's right.
And if they do damage,
that's right,
you're responsible.
Yep. And the proposal being put is that in domestic violence situations that shouldn't be the case. That a tenant shouldn't be held responsible for the damage done. So if someone comes in and punches holes in walls and whatnot, the tenant not be held responsible. And
that's the landlord, isn't it?
It's very difficult for the landlord, and again that's strongly being opposed by property groups. The other thing that is being advocated is that a tenant can't be listed on a tenancy default database for damage to property or rental arrears if the situations surrounding those two breaches are as a result of domestic violence. So there's quite a lot in it. REI put forward an interesting proposition where they're saying, look, you've got all this money, and we mentioned the figure earlier, how many billions they've got, and you take the interest from that bond and you set up a special fund, and in circumstances where properties are damaged, money is used from that fund to fund repairs and damages. But how workable that would be is still to be seen. I mean, something has to change, but whether or not it goes as far as what's being proposed.
When are they looking to bring out the legislation around this, do you know?
Well, it'll be coming shortly. I think the parties have put their submissions in, and you know there are proposals that are currently out there. It obviously has to go before Parliament, but it's just about striking that balance.
So you're thinking they'll be out this year?
No.
No. Okay.
No, I don't think so.
2018.
Yeah, possibly.
Right. Obviously, there's a lot of discussions still happening.
Oh, look, there's still discussions trying to find that balance. And I mean, domestic violence is a very big issue, an important issue, but we have to just strike that balance. The other thing, I mean, owners need to be protected as well, and ensure that people that they put into the property are going to look after it and have those additional rights protected through the tribunal. Otherwise, you could have a situation where if an agent knew that a tenant was involved in a previous domestic violence situation, you may have tenants being discriminated against based on that, and they don't get rental properties, and you don't want that situation occurring.
Lisa, that's very interesting indeed. We've just got to wait and see what they do and all the discussions around that, but we'll be finding that, say, hopefully next 12 months.
Yeah.
Thank you very much.